You have now been convicted.
Yeah.
Have you learned anything? Would you do anything differently next time?
Ari, for better or for worse, I'm going to be a figure in history in a landmark Supreme Court case. And the question really before us is whether the legislative branch can compel a senior White House aide and alter ego of the president to testify before Congress. And going back to George Washington, the answer has been a resounding no. And the DOJ, the Department of Justice, has had a more than 50-year policy of absolute testimony immunity for folks like me. So I am willing to go take this up the chain, the appeals court, probably to the Supreme Court, to resolve this issue because it's so important. Not just it's a bipartisan concern. If you don't have the constitutional separation of powers, Ari, you cannot have effective, efficient, candid presidential decision.
That sounds a bit like
that goes back to George Washington.
It sounds a bit like a no to me that you're saying, having been convicted and facing possible prison time, you're going to appeal and you stand with those arguments. Okay. Since we last spoke, other people, as you know, have been indicted for charges related to trying to steal the election. You have not. This was for you on a subpoena issue, but I want to put up on the electors plot.
Correct.
States overturned the votes, which is something you and I discussed. Pence overturned the votes, DOJ interference, and, of course, separately, the violent sedition. Do you now see that it can be a crime to try to overturn lawful final votes in this country?
Ari, let's just stay with my case. I was charged with failing to comply with a congressional subpoena.
Yep.
Full stop. That's it. Got nothing to do with any of that other stuff. There's no reason for me to comment on that. For your viewers,
well, I'll jump in. I'll let you finish.
You can choose to. You can choose to.
I'm going to jump in and let you finish.
I have no comment on those other cases.
That's okay if you have no comment. I will say for the record, you did say publicly, well, the plan was to use the 6th certification, to remand it back to the states, to get Republicans in those states to overturn the vote. That is related to some of the plots that have now been charged.
Yeah. Let's clarify some things here. The issue here is the Electoral Count Act of 1887, which came in after the 86 election was marred by tremendous problems and fraud. Okay. And it was perfectly legal to use the Electoral Count Act of 1887 to ask for a legal recount of votes. And that's where I was coming from, as I wrote about in the Green Bay sweep, full stop. Okay. Well, the rest of this, to me, is noise, not signal.
Okay, and I understand
again,
where you want
to stay with my case.
I understand that, and we've had other guests who say, "Hey, I'm going to talk about this and not everyone else's case."
Sure.
In your situation, Donald Trump never personally invoked privilege. Did he ever pay for any of your lawyers or legal fees?
Let's start with the first question here. I provided evidentiary testimony for probably 40 minutes where I documented 5 phone calls, a visit to Mar-a-Lago, all with the president, numerous emails, phone calls.
And we covered it, and the judge rejected it as they didn't have what they needed. They didn't have Trump. All he had to do was write it. He tweets a lot. He posts a lot. He never wrote, I give Navarro privilege.
Slow down, okay? Because this is what the appeals courts are going to have to deal with. We made, in my testimony, very clearly indicated that the privilege had been invoked. And from this outset on your program, when you showed that clip, I said from the outset to the committee, to the Department of Justice, privilege invoked, not mine to waive. Please go negotiate. And
we covered all that. And I think longtime viewers will remember that. I'm only interjecting to say, if he didn't do that and he didn't pay for your legal fees, right, is that fair?
Hang on. Well, that's a separate thing. He has certainly helped with my legal fees. But what's fair here is the fact that he did invoke the privilege, and I got 5 phone calls and a visit to Mar-a-Lago.
Right, you've asserted that in court, and we've covered that. The judge rejected that.
Hang on, he just correct, but the judge, in the judge's view, he didn't feel that that was, quote,
right. And I think that's on the record that you.
Now, this is why.
But, Peter, I'm jumping in. Not
this
to,
is why there's
you'll
an
get
appeals
time, but I'm
court.
jumping in to say, yes,
Yeah, sure.
You're going to take that to the appeals
Sure.
court. That's on the record. How much did he help pay for your legal fees, Donald Trump?
About $300,000. My legal fees are well in excess of $6,000. I've been raising money through defendpeter.com. Defendpeter.com. If you're interested to see any out there in MSNBC land wants to help out, defendpeter.com. This will be at $1 million case. And Ari, part of the problem here is this lawfare, this notion of if you can't put me in prison, you can at least bankrupt me. And I'm not a wealthy guy. I wasn't one of the wealthy guys in the Trump administration. All I ever did was create jobs, save lives, and settle labor strikes. And I thought I did honorable, productive service to this country.
And so the $300K that Trump got
with a lot
for
of legal
you,
bills.
I imagine, did you ask him for that?
Sure, certainly.
Yeah.
Look, he's been a rock on this, okay? This quibble about what a formal invocation looks like is going to be a big part of the appeals process. This is what's important, Arnie. The judge clearly said during the case, if I went in and selectively invoked the Fifth or privilege, I would have forfeited my right to absolute testimonial immunity under Department of Justice policy.
So let me put up the witnesses on the screen, and you made your point, and I think Congressman Lofgren and others have said publicly, yes, people have an obligation at least to come in and engage, even if they have reasons they want to assert for not testifying. But over 1,000 witnesses did cooperate, Peter. 34 took the Fifth, something you just alluded to. There are other ways. None of those people are in the trouble that you're in. And so I guess that's part of the question of why this is all worth it. You said you want to litigate this. I do want to turn, and I'll let you get more time, but I do want to turn to what you mentioned.
Let me just address your statistics.
Okay, briefly on the statistics. Go ahead.
How many of those 1,000 people were senior White House advisors and alter ego of the president? Zero.
Not zero, sir.
Zero.
Some were
zero.
Mr. Meadows was your boss. Mark Meadows was chief of staff.
Meadows never testified. Meadows and Dan Scavino.
Well, let me be clear, and then I'll let you finish.
The same thing I did.
He didn't do the same thing you did.
I gave him some documents. He did not testify.
Okay, let me respond.
You did not give him the documents
and look,
they wanted.
Mr. Navarro, we've had our back and forth before. Let's do that again.
Sure.
You posed the question, what's the difference?
All right, call me Peter. Come on.
All right, Peter.
We do that when we see each other.
Okay, I'll call you Peter.
And we'll keep this. I mean, this is cool. This is good.
I agree. And America, if I may say so, benefits sometimes if we do this. So here's the deal.
Yes, sir.
Mr. Meadows, I call him Mark if you want. Mark Meadows went in there and engaged. He provided testimonial reasons why he said he couldn't actually speak. He provided thousands of pages of documents. His lawyers engaged. Let me finish.
Testimony.
You just said.
No.
He said he provided the reasons of why he said it was privileged, and so he litigated that out. He was held in contempt, but the DOJ didn't charge. Same for Mr. Scavino. They didn't charge him. And so you also asked, what are the other people? Well, you have a bunch of White House lawyers. As you know, some of them have arguments that part of this is legally privileged. We get that, but they showed up. What you did was defy the whole thing. And I guess at this point, you still don't either see or acknowledge why that's different. But the question is, do you think Trump can beat this case in Washington against Jack Smith?
No, I don't. And here's the second issue. The jury. I mean, you asked me about voir dire. Again, I have great respect for the jury. They took their time out. They did their civic duty. Fine. Good. But 50 people went through voir dire there. There wasn't a single Trump supporter in the whole bunch, and there were many people who expressed concern or animus towards Donald Trump, yet they still could be seated. They still could be seated if they said that animus would not affect their verdict. And we know in the district it's 92% voted for Biden and over 60% registered Democrats. And it's like, look, if I had a jury and I pulled it from MSNBC versus Newsmax or Fox, you might not come up with the same outcome. So I think that's going to be a tough thing.
Understood.
And by the way, you didn't mention the most interesting thing about the jury. They let my jury out in the middle of deliberations into a group of protesters and a mass of media.
Yeah, I read that. I read that
the jury
piece.
Goes back in.
Well, I read that. I got to keep it. I gave you time, Peter.
That's a whole nother thing.
Yeah, I gave you time, but I want before I let you go. When you take this all together, and we do appreciate you coming back. And again, people can hear this, all make up their own minds.
Sure.
But when we take it all together, you were out there discussing aspects of what you call the sweep or this plot for January 6th in public. You took this fight all the way through the committee, through the quorum, through DOJ. And now you might risk going to prison in losing this legal fight for refusing to describe under oath what you had described in public. Does that make sense? Was it all worth it?
That's not okay. Look, first of all, and last of all, I did the honorable thing. I did my duty to the country, Constitution, and the law. The president invoked executive privilege, period, full stop. Maybe he didn't do it to the liking of the judge, but he did it. As soon as he did that, it was not my privilege to waive, which I said earlier 18 months ago on this show. And I also asked the committee, as well as the DOJ, to negotiate a waiver, in which case I would be happy to talk. My hands were tied. My hands were tied.
Yep.
And the judge acknowledged what I was in. And last thing I'll say about that committee, I mean, look, the congresswoman you had on there were 9 people on that committee. 7 of them had been involved rabidly with the 2 impeachments of Donald Trump, and 2 of them were Rhino Republicans in Cheney and Kinzinger. Okay, and it was not legal. I mean, that was a witch hunt. Okay, but
well, look,
the principle
I gave you
here,
time.
Ari,
I gave you
the principle here.
Final
is the
point here, because I gave you time,
separation
sir.
of powers. That's it.
Okay.
The constitutional separation of powers. If it says on my tombstone, I stood up for that and defended that, I'll die a happy man.